like an eighth grader's view of the world is why we won this case.
Hello, my friends, and welcome to the Personal Responsibility Lawyer Podcast. I am your host, Michael Lovins of the law firm Lovins Trosclair. My guests on the Personal Responsibility Lawyer Podcast today are Jeff Edwards and Mike Singley, who are two of the best trial lawyers I know. As soon as I decided I was going to create a podcast, I knew that I wanted to interview these guys and I wanted to talk to them about this case. The case is a claim that's based on the Eighth Amendment to the U.S. Constitution. Now, the Eighth Amendment says, quote, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." Close quote. That's it. I didn't leave out a single word. Now, the most famous part of the Eighth Amendment, of course, is the cruel and unusual punishments clause, and that's what this case is about. Jeff and Mike and their team sued the state of Texas in federal court in Houston. For now, let's just leave it at the fact that they won the case, and Texas appealed to the Fifth Circuit. Now, for our non-law nerds, I want to give you a really short primer on the federal appellate system. It'll make a lot of this make more sense if you're not familiar with it, and most people aren't. So when you file a federal lawsuit, you file it in the federal district court, and you have to get it in the right geographic location. You may have a few different choices on where you can file it, but you can't just file it anywhere you want to. And the district court that's the court where trials happen. Once the case gets decided by the district court, whichever side doesn't like the result can appeal it to the circuit court for that geographic region. The circuit courts are right above the district courts in the hierarchy, and they're just below the U.S. Supreme Court. The circuit courts have to hear and decide all of the appeals that come from the district courts. They don't get to say, no, we're not going to hear that case. If you don't like the circuit court's decision, then you can appeal it up to the U.S. Supreme Court, but the U.S. Supreme Court has discretion to say, yeah, I don't think we're going to listen to that case. We're not going to decide it. So the circuit court's decision stands. I've left a couple of steps and a few details out of this, but this is the basic process. So there are 13 federal circuit courts. 12 of them cover geographic areas, and one of them is this kind of weird court that deals with intellectual property kind of stuff from all around the country. I'm going to ignore that one right now. It's called the Federal Circuit, and it has nothing to do with this. So right now, the Fifth Circuit, which covers Texas, Louisiana, and Mississippi, has 17 judges. So when Jeff and Mike won this case in the trial court in Houston, Texas appealed it to the Fifth Circuit because that's the appellate court that covers Texas. But when you go to a circuit court, you don't get all of the judges. Each court has a different number of judges. Fifth Circuit has 17, but you only get 3 of them. And then your case is decided by a majority. So at least 2 of these judges have to agree on whatever opinion they issue. Now, the Fifth Circuit's reputation is that it is one of the most conservative, if not the most conservative, federal appellate courts in the United States. And most people would expect that any appeal that you bring fighting for prisoners' rights to be dead on arrival at the Fifth Circuit. So in this case that we're going to talk with Jeff Edwards and Mike Singley about in just a second, Texas lost 3 times at the trial court, and they appealed to the Fifth Circuit, the very conservative Fifth Circuit, 3 times. So the first appeal, Jeff and Mike won. The second appeal, Jeff and Mike won again. But on the third appeal, this is a little different, because on that one, Jeff and Mike won, but then the case settled. And it still has some court oversight to administer just exactly how this happens, but basically the case is over. There will be links in the show notes at michaellovins.com/Edwards-prison if you want to go full-on legal nerd mode and read some of the key case documents and opinions. I'll have links to all of that right there. So with that background info and that short civics lesson, here's Jeff Edwards and Mike Singley. All right, Jeff, Mike, thank you guys so much for being on the program. I want to jump right in, and I want to hear what this case is about, who we're talking about, why it matters, what happened, and how did it get fixed.
This is Jeff Edwards. We filed a lawsuit in order to protect inmates who were at grave danger due to the fact that Most of the prison system in Texas is not air conditioned. This case stemmed from the PAC unit, which is a geriatric prison, which has a high population of people with medical problems and a high elderly population. The case was very simple at its core. It was, should people be subjected to temperatures and humidity levels that endanger their lives and worsen their already deteriorating medical conditions? We had a very simple philosophy, and the answer was no, that in our society, once you're convicted of a crime and your liberty is taken away, that the state has an obligation to protect them from known dangers. We learned over the course of time that one of the most prevalent dangers and one of the most dangerous things in the prison system was the heat to which these inmates are subjected to. Over the course of several years and roughly 40 depositions and retaining leading experts in the world, frankly, we convinced a federal court in Houston that the situation was untenable, the situation was dangerous, and that the situation needed to be fixed. And to the state's credit, following those injunctions, they came to us in an effort to solve this problem, at least at the PAC unit, and we were able to settle the dispute by air conditioning the PAC unit and by giving the inmates who were housed there access to air conditioning in the future.
So let me ask you a couple of sort of detailed questions. What on earth is a geriatric prison?
Yeah, Michael, so this is Mike Singley. It's an older population. Geriatric's kind of a fancy word for a population that's older in age. And what goes along with that is a population that's got more diseases and is sicker, as sort of naturally happens as you age. So one of the things that was particularly poignant about that prison is that fact that there were a lot of vulnerable people. The majority of the beds in the Texas state prison system don't have air conditioning. But it's one thing, it's not good for anyone, but it's one thing when you're 20 and perfectly healthy, and it's another thing when you're 70 years old and you have diabetes and high blood pressure and are on medications that make you heat sensitive.
So what types of conditions did these prisoners tend to have, and were they moved to the PAC unit because of those conditions, or was it because of the types of offenses or the types of other security they needed? How do they decide who gets in this particular unit?
Well, the types of medical conditions are the types of medical conditions that you or I might have as we grow older. They're diabetes, COPD, hypertension, psychiatric conditions that require medications that dehydrate you. When I say geriatric prison, the PAC unit has a layout that caters towards an older population. It's a lower security unit, which due to age and the offense levels, it's very easily managed, and it actually has on-site medical care, regardless of anyone's opinions of the quality, that inmates can access. They can go get medications on their own. There are people there 24 hours a day, 7 days a week in cases of emergency, which highlighted the importance of dealing with this heat. The heat posed a particular danger to all of these inmates, especially the inmates with conditions that, rendered them more vulnerable. And that ranged from, taking a medication for a psychiatric condition that dehydrates you to naturally occurring vulnerabilities for someone who has hypertension or who has diabetes or is dealing with lung particulates like COPD or asthma, things like that.
So prior to when you filed this lawsuit, how hot was it in this prison? Of course, during the summer months is the time that we're worried about it, I assume. And in January, it's not a big problem, even in Texas.
No. Well, it's interesting. All of the prisons in Texas do have heat, so they eliminate the potential danger of freezing to death, much that you'd be worried about in Chicago. What you should be worried about in Texas is how hot it gets. There's an obvious solution to that that's been known since, the 50s, and it's called air conditioning. But in terms of, I apologize. I kind of got off track.
I'll jump in here, Michael. I think you were asking about what temperatures we were seeing in this prison in the summer. And first of all, just one kind of introductory thought about that what we were really looking at was not just the temperature in degrees Fahrenheit, but in what's called the heat index that builds in a concept of humidity. Because building in the humidity as well as the temperature is very important for the effects on health. And it's sometimes called the apparent temperature, because when you add humidity, as we all know, for those of us who live in Texas or hot places, when it's humid, it feels a lot worse.
It's not the heat, it's the humidity.
It's not the heat, it's the humidity. And there's a lot of truth.
I just came up with that on my own right now.
Yeah, it's a new one for you. But it's relevant for the health and safety aspect too. So things are measured usually in the science and medicine of heat in terms of heat index. And so you would see heat index values, well into the hundreds and high 90s very frequently. This prison's in Navasota, which is not far from Brenham, so it's a hot, humid part of Texas, maybe even by some Texas standards.
And over the course of the litigation at this prison and other prisons, we saw heat index readings as high as 150 degrees. So on a consistent basis.
Let me make sure when you say 150, sometimes sounds like 115, but I think you said 150.
I said 150. I said 140, 135 degrees.
Wow.
These are heat indexes that the governmental agencies describe as dangerous and in which heat stroke is an imminent problem. An imminent meaning it's going to happen. At the PAC unit in particular, we hired, there were temperature readings done, and these heat index readings all exceeded 100 degrees on a consistent basis. And it was a foregone conclusion that every summer there would be temperatures in the 90s, 100s, 110s, and depending on whether or not there were heat waves or depending on how the summer went. Certain summers are going to be hotter, but what we learned was that while there would be variations in heat indexes over the summer, there was a consistent baseline well into the 90s and the low hundreds, and the overwhelming evidence from even the state scientists was that the temperature was going to keep getting hotter, and therefore the danger was going to keep increasing.
So one of the things, I actually prepared for this a little bit.
Unsurprisingly.
Yeah, we're lawyers. We can't help but get a little prepared when we walk into something. But I think I read in the judge's injunction order that they recorded the temperature and the heat index inside the prison prior to when you filed the lawsuit. And then at some point, I don't know if it was immediately when you filed the lawsuit, but very soon thereafter, they stopped measuring the heat and or the heat index inside the PAC unit. What's the story? That seems just crazy to me that you get sued, and I mean it just looks terrible. You're trying to hide something. What's the story there, if you know?
I think you just expressed the story in as clearly as you could. With any huge bureaucracy, people tend to be afraid of the light. And they were taking these indoor temperatures because they knew they had a problem, and they knew they had a danger, and they knew they had to document it. The problem was, though they were documenting the danger, they weren't doing anything with the information to protect people, and they certainly weren't alerting policymakers at the legislature about these dangerous temperatures. They were simply documenting it. And when we got into the litigation and demanded those records, they determined that they would be giving us evidence that they perceived as beneficial to the inmates and beneficial to the plaintiff's counsel. So they stopped. From a tactical standpoint, you're exactly right. It was a foolish decision. It was either done because there was bad advice, or it was done to deprive the inmates of the ability to access that evidence. Now, the state was facing lawsuits from our law firm, who represented a number of people who died as well, and the state was trying to avoid providing evidence that would be damaging to the injunction case at the PAC unit and to cases involving the wrongful deaths of so many people. as any lawyer will tell you, it was a short-sighted decision, and from an absolute matter, it clearly backfired because Judge Ellison, who heard this case, drew the same conclusion that you drew. The only reason to stop doing something is if you're afraid of what the results show. And if you're not afraid of it, and you do think your prison is safe, you ought to be doing what you were doing before this lawsuit. Again, over the course of time, the people that were representing the state changed, and I think the opinions of what needed to happen also changed. In any litigation, from my perspective and from Mike's perspective, in order to win, the first people we have to convince are our opponent's counsel. And though it took a significant period of time, I think eventually, with some tremendous help from rulings from Judge Ellison, and after thousands of hours, ultimately they were convinced. They were able to convince the powers that be at the Texas Department of Criminal Justice that they were going to lose, and then took some steps that I describe as very proactive, and in terms of successfully convincing us that they were serious and resolving the case to the betterment of thousands of people's lives. And it will be interesting to see if the settlement and the on paper or the actual air conditioning of this prison proves to be a template for what they do with other people. And I think that there is a very real chance that while our technical injunction and settlement only applies to the PAC unit, that it will have repercussions and significant benefits to the entire inmate population. We've already seen that with the department's decision to air condition a unit that catered to inmates with intellectual disabilities. Now, you might ask why, and that was the Hodge unit outside of Tyler, Texas. You might ask why they did that. They did that because someone over there, probably their lawyers, identified that as a huge risk factor, because over the course of tens of depositions, I told them that it was a huge risk factor. And we had people who died there in our wrongful death cases. And so we made the point that, look, you're discriminating against people with intellectual disabilities who can't help themselves. You need to air condition that facility as well. And so, again, I will say to their credit, they've at least publicly represented that they're going to do that. And so sometimes, I forget who said it, maybe it's The Art of War or something. Sometimes the best wars are fired without a single shot. And we're deeply hopeful at the firm, and I think the inmates would say this as well, that the fact that we won these injunctions, preliminary though they may be, and resolved the case so that air conditioning became a basic right at the PAC unit will play out such that other inmates eventually get that right. And that's what I tell policymakers. This is a core human right that we're talking about. There isn't a single public building in the state of Texas that doesn't have air conditioning. That could be the DMV, a library, or even a county jail. The only people that are subjected to dangerous heat indexes in the 90s and 100s on a consistent basis are people in the Texas Department of Criminal Justice prison system. Every county jail has air conditioning. Every city jail has air conditioning. Every federal prison in the state of Texas has air conditioning. The only one is the Texas Department of Criminal Justice, and it's about 70% of their facilities. And the rationale, though never completely espoused, is a misguided political mindset that inmates don't deserve these basic protections. What we learned, I can't even say it was to my surprise because it kind of is the way that I think, but almost everyone, when you take liberty away, believes that the state has an obligation to provide protections. And when you're able to explain that lowering the temperature is an issue of saving lives and not just making people more comfortable, most people are easily convinced. I tell the story that practicing 1983 law or constitutional litigation is well known to be difficult and complex because of all the immunities and all the hurdles that you have to overcome. But when I tell this story to, my son's 8th grade class or friends and family from where I grew up, no one's particularly impressed by the fact that we got air conditioning in a prison or non-arsenic water in a prison. They kind of come to the conclusion, well, do you really have to be a good lawyer to win that case?
Come up with something more impressive to tell me.
And to that I quickly respond, well, were it so
yes.
easy?
As it turns out, yes.
Yeah. Ironically as it turns out, yes.
Ironically, yes.
But they're kind of like an 8th grader's view of the world is why we won this case. We won this case because we live in Texas. There is nobody with any means who spends any time in a non-air conditioned building or a non-air conditioned home. I would joke that, oh gosh, I remember when a lake house air conditioning went out. I couldn't make it more than an hour. I've been in a conference room in this building when air conditioning went out with high-priced lawyers from New York, California. I've never heard more complaining in my entire life. This is while the heat litigation is going on. I've literally been in depositions with the Department of Criminal Justice where they say it's too hot in here. Could we open a door? And on the record, I get to make jokes about this. But unfortunately, for the inmates we represent, the 70-year-olds, the people with COPD, the people who have schizophrenia, and everybody knows they're in danger. It's not a laughing matter. And while we were tremendously successful at the PAC unit in convincing the state that this was a danger, there are still people in jeopardy. And this is an issue that should continue to be discussed because, unfortunately, the class action we won applies to one prison. Perhaps it should apply more broadly than that, but it's really in other people's hands. And will there be more litigation if the state chooses to continue to allow this danger to exist? Of course. But, even the mightiest waterfall begins with but a single drop, and that was a theme at these injunctions, and it's true. And we're hoping that, this prison system being air conditioned is the start of better things to come for many, many inmates. Which in my opinion is not just better for the inmates, but it's better for all of Texas. One thing that Mike and I learned over the course of this litigation is how many people have connections to the prison system, and how it's not 3 or 4 steps removed. Everybody has a nephew, an uncle, a friend of a friend in this system. And when so many of the people that are in the prison system are there for nonviolent drug crimes or for parole violations, and with the prison system aging, it's a no-brainer to protect people. And even leaving that aside, if you live in Texas and spend time here in the summer, it is just unbelievable to me that you don't have this basic innovation of air conditioning, and that you have a mindset that that's okay, because nowhere else are people subjected to this on this basis. And when you compare a county jail to the prison or a federal prison to Texas, there's just no reason to subject people to these conditions, because you know that they can kill someone. And regardless of your view on crime and punishment, the punishment is the prison sentence. It is not to kill someone in the prison. And just like we provide health care and we stop people from taking a shiv and attacking somebody, when you know about a danger and you have the ability to stop it, it's not a stretch that you ought to stop it. And preventing heat-related illnesses, and particularly heat stroke in prison, unlike many other problems, is a completely preventable thing. It is a completely preventable problem. All it takes is air conditioning. So all it takes is modest sums of money to fix this problem. And from an economic standpoint, there's a tremendous benefit, because when you're talking about the heat worsening people's medical conditions, what that means is that medical care and medical costs are going to go up in the prison as a direct consequence of not providing cooler safe temperatures. So whether you're looking at it from a moral standpoint or from an economic standpoint, this was a basic issue that everybody could get behind, because it just made sense to provide air conditioning. I mean, again, at its core, it's the right thing to do, because you have a danger, you know how to alleviate it, and all you have to do is spend a little bit of money, and you end the problem of heat stroke in prisons. And this is not an academic, semantic argument. More than 20 people have suffered heat stroke simply because they had the misfortune of living inside these brutally hot temperatures.
And that's died of heat stroke,
right?
Not just suffering, dying.
Hundreds of people have suffered heat strokes where they didn't die. Hundreds of people have suffered heat-related illnesses. More than 20 died. In 2011, 10 people died of heat stroke. Now, to put that number in perspective, the state's own expert said it would be an epidemic if 2 people died of heat stroke.
Wow.
Now, here's what was amazing to Mike and myself. Upon discovering that 10 people died of heat stroke, alarm bells did go off. They knew they had a problem. They knew it was of epic proportions. And here's what they did. They internally documented it and moved on. And they didn't implement any protections. And 2 more people died the next year. And so, again, what this case was all about was getting to the very top of the prison system and having a conversation with them. Now, it was a conversation under oath and in a deposition. But here's what I've learned about asking questions of smart people. And by and large, though they weren't doing smart things, the people running prison systems at the very top are smart people. But here's what smart people don't like. They don't like to answer questions in which they seem foolish, or in which absurd examples are posed to them that they have to answer absurdly. And after a while, the obvious answer rings true, and people can't defend what's going on. And so, again, people who run the prison system don't do it for money. They do it because they do have a genuine caring for the inmates under their protection. They do have a basic philosophy that the law is important, and that people need to be rehabilitated, and that people have a right to live in a good fashion and better themselves. And that's what prison's all about. Sometimes with a bureaucracy, people forget that just because they perceive something to be difficult, like asking a legislature for some funding for something that they perceive to be unpopular, that they have to do it because morally it's the right thing to do. And so we had the opportunity, Mike and myself, to remind them of that. And we did it in a very sharp manner. I mean, oftentimes I would turn to my colleague, Mike Singley, and say, "Is that too much?" And his comment to me would simply be, it's almost like they killed people. It's almost like you're treating people like they killed people. And again, I don't say that out of any enmity towards the administrators of the prison system. And I don't pretend that it's the same thing as affirmatively going out and trying to kill people.
Sure.
But the fact of the matter is, if your job is to care for and protect people, and you purposely don't do it, and purposely allow people to die, it's your responsibility. And after a while, after answering those questions, very hard, difficult, but direct questions, there was only one conclusion to draw. These people were in danger, more people were going to die, and the system needed to be changed. We had the added benefit of having, multiple victories in federal court, and so I'm not naive enough to think that without us winning, the system would have changed. But once we began to win, then the people who mattered took notice, and it became a problem-solving situation rather than another 10 years of protracted litigation. To that, I have to compliment the state. I think it took them far too long to get there, but I would rather live in a state where policymakers eventually get to the right decision rather than just fight no matter what. And so I have to pay the state's lawyers and the administrators some credit for that. I mean, Mike, what do you think?
I agree completely. Absolutely.
Before you guys filed this lawsuit, so the heat indexes were getting to insane levels. Were they doing anything? Obviously, they didn't have air conditioning. Were they doing anything to help the inmates with the heat, with the health issues that come from the heat?
They were encouraging inmates to drink water on paper. Now, at the PAC unit, that had the ironic twist of encouraging them to drink water that had 4 times the level of arsenic that the EPA says is safe. So ironically, at the PAC unit, the solution was to
drink more of our arsenic.
And I'm not,
you'll cool down.
And I'm not kidding. And the response to that was, well, 4 times the level of safe water is just a modest increased risk in cancer to the inmates, and so it's something that still should be done. I'm not kidding. That was the argument.
I don't want to spend a lot of time on this, but I noticed that there was just very early in the order, there's a reference to the arsenic water. Where do you even get water that has too much arsenic in it? Are they on their own water system?
Yes,
I don't get that.
Yeah, it's a well. They had dug a well there, and arsenic is a naturally occurring mineral. And so, sometimes when you sink a well, you can have arsenic in the water, and that's where it came from, their own well.
But apparently that wasn't terribly difficult for them to fix, because that didn't become a focal point of the litigation, based upon what I read in the orders. Is that right?
Well, it's not difficult to fix. It just requires some time, effort, and a little bit of ingenuity. It wasn't a focal point because the first injunction that we had, we won, and Judge Ellison ordered them to fix it. And they said, we will fix it. And so as soon as the judge ordered them to do it, guess what happened? They fixed it.
And the solution's a filtration system that you put in order to take care of that.
Now, I might add that prior to our demanding they fix it, the problem had been going on for 10 years, which we found, frankly, to be a little bit too long, regardless of your opinion of government work.
So you made the moral philosophical argument, and you made the economic argument. But in the lawsuit, you brought some specific claims, one of them being the constitutional argument. So tell us about what's the constitutional argument that not just is it a good idea morally or economically, and not only is it in some kind of I don't mean to minimize it, but an abstract sense, it's philosophically and morally the right thing to do. But the Constitution doesn't require all good economic decisions or all morally right decisions. Why did the Constitution require air conditioning in this case?
Michael, that's a great question, and I think you've really keyed in on one of the most important parts of this case. It's about the Constitution and constitutional rights, not just taking a look at something and saying, that ain't right. The Eighth Amendment to the Constitution is what we invoked here, which prohibits the government from inflicting cruel and unusual punishment on people. And when you're in a situation where you have prisoners, and the state has prisoners under their care, they can't treat them in a way that inflicts cruel and unusual punishment on them. And what we had here, the constitutional case and the constitutional right being violated, is that by subjecting these prisoners to levels of heat that are medically dangerous, that's cruel and unusual punishment. And so there's kind of 2 pieces there. The law piece, a big part of it is the constitutional right that applies to everybody, including some of the least among us, like prisoners. And I think that puts a dimension on the case that's maybe different from other cases. In the Constitution, it's a big thing for the protection of society. When someone's constitutional rights are violated, all of society suffers. One thing we can really all agree on, Americans, is the importance of the Constitution and upholding everybody's constitutional rights. That's the first piece of it, that really important constitutional framework. But the second piece is, it's about safety and medical risk. It's not about comfort. No one's coming in saying, let's be cushy on the prisoners. Let's get things cooled down to 70 degrees for them. Michael, what we asked for and what was at issue on the temperature rulings is just make sure it doesn't go above an 88-degree heat index. And for those of us living in Texas or hot states, we all know that's uncomfortable and miserable all day long. So there's no aspect of saying we're going to try to use a big legal idea like the Constitution to be cushy on prisoners. What was at issue here was people dying or having serious illness, dying of heat stroke. And what we anchored that to was the science. People have studied heat waves and disease and death caused by heat waves for a long time. And what you see when you look at the science and the medicine is there's a very clear risk point that starts in a dramatic fashion after about 88 degrees heat index. So that's really what was at issue there.
And I saw there were a bunch of experts hired by both sides in this thing. And so where does the heat index become dangerous? And then one of the other things that you mentioned, I think it was at the Hodge unit, that is is it intellectually challenged?
They call it the DDP, the Developmentally Disabled Program. And so for folks with varying kinds of intellectual disabilities.
So why, and also at the PAC unit, a lot of the guys there had some kind of, they were on like psychotic medicines for various mental health issues.
Correct.
What I had no idea about before reading some of this, and I still don't quite understand, so maybe you can help us a little bit. Why are those people more susceptible to heat and to heat-induced illnesses and potentially death?
Sure.
Yeah, so there's a variety of different answers depending on the specific drugs and conditions. But for example, a drug called a diuretic that people take frequently for treating high blood pressure. Diuretic, people will refer to them as water pills. Well, that reduces your ability to have your natural sweating mechanisms through your bloodstream to be able to deal with the heat. So when you mess with, there's in very simple terms, when you mess with the water level with a drug like that, you mess with your ability to cool by sweating. That's one example. There are other drugs that can constrict the blood system, which make that harder. There are also some of the drugs that interfere with various, without diving too deeply into some of the arcanery of this, sure. The psychotropic medications that people can take for depression or schizophrenia, those can interfere with some of the bodily systems that regulate sweating. So sweating, like a lot of bodily functions, involves neurotransmitters, signals that are sent from the brain to the parts of the body, and some of those drugs disrupt the signals that get sent either to make the sweating mechanism work right, or there's a bit of a central thermometer function in the brain, and some of those psych meds can interfere with that function as well. But there's a lot of different answers depending on the drug or condition.
Then another thing I noticed reading about all of this in the orders, and this aroused my curiosity more for not even related to this particular litigation or the lawsuit or even the prison issue. But they had fans. At least some of the inmates had fans. But the experts, and I think both sides' experts agreed that at some point, fans, not only do they not help, they're worse.
Yeah. You asked a question earlier about things that they were doing, and I mentioned water. Another thing that people were relying on were, in theory, fans. And what we learned from our experts, and ironically from their own internal PowerPoint documents, is that once you get past about 95 degrees, fans are actually counterproductive because they mask the effects of the heat, and they actually hinder the body's ability to deal with heat dissipation. And so, again, until you really dive into the issue on an intuitive level, fans make a lot of sense. And they made a lot of sense when the prisons were like you might envision in Cool Hand Luke, with ventilation drafting through, and when prisons were built that way, or jails were built that way. But now when they're built with concrete and metal and don't have ventilation systems like that, the fans don't provide any meaningful respite or protection from the heat. And even worse, they make it more dangerous. We would point this out to them, and there was some fighting on that, but eventually people came around. And so, again, it's like telling people to drink water with arsenic. Telling people to use fans when it's 105, 110 degrees is so counterproductive that you just have to question people's sanity. That's why air conditioning is really the only remedy here. Because it's the only thing that will take the which will reduce the temperature to safe levels. And irony of ironies, the prison while there's no formal prison standard regulatory body, there are organizations out there that recommend standards to which the Department of Criminal Justice leadership brag about fulfilling. There's a standard out there that says if you want to run a humane prison, you should have temperature controls that can raise and lower mechanically the temperature depending on how hot it is outside, which makes perfect sense because in a heat wave, it's going to go up and you're going to need to be able to lower the temperature. They just chose not to follow that standard. In irony of ironies, when Mike Singley deposed the expert on the issue of air conditioning for the state of Texas, he candidly asked him, well, boy, would you ever build a prison like this? And I think the response was, well, now or back then? And Mike said, either. And he said, no, I wouldn't. And the reason he wouldn't is because no engineer of any competence would have ever designed a building that didn't have air conditioning. I mean, outside of Houston, Texas, there's the Amazon and a Houston parking garage, and they're the equivalent for heat index levels in the country as far as I'm concerned. I mean, that's what these guys, and I say guys because it's a male prison, that's what these guys are subjected to on a daily basis. I mean, to say it's cruel and inhumane is to put too kind of spin on it. And following up on what Mike was saying about the constitutional provisions that we were talking about, there are really two issues. What makes something cruel and unusual? It has to do with if you have a known danger that you know poses a substantial risk of harm to an inmate, that amounts to cruel and unusual punishment. And here, the cruelty was obvious, but the substantial risk came in the form that death was one of the options. Heat stroke was one of the options. Worsening lung conditionings, worsening heart conditions. These were what inmates were subjected to. And there's a second piece of the constitutional puzzle that has to do with evolving standards of decency and how those are measured. And the fact of the matter is, virtually everyone in the state of Texas has access to air conditioning. I suppose there are places out there where you can choose not to, and there may be hovels that don't have it. But there's nothing that the government's built outside of these prisons since 1970 that doesn't have air conditioning. And so our argument was simple, that as society evolves, as air conditioning goes from being a luxury to commonplace, much the way that air travel is now necessary to get around the world and do business. In 1945, air travel was a bit of a luxury. I concede that. Now, if people need to go to El Paso, they can get on a Southwest plane. The standard of decency, the standard of that we expect, changes over time. As technology makes things more readily available. In this case, it did that in 1960, but so we waited 50 years or so, or 60 years.
Geologic terms, it's not that much.
but in the grand scheme of things, technology is going to make things much more possible, and that's one of the beauties of the Constitution. Regardless of your view of it, in measuring what's cruel and unusual, the fact is, what may have been cruel and unusual now may not be viewed that way in 1789. But we have a society where everybody has air conditioning. It wasn't even in place until 50, 60 years ago. And because it's an option, we made it pretty clear to them that they ought to be taking advantage of it, especially because it happened to be a solution that completely, 100% solved the problem. Anyway, and I'll talk more about it. They knew this not only for the human beings in their custody, care, and control. I mean, they knew it for the livestock that they took care of and used to feed the prisoners as well.
Wait a second. I didn't see this in the orders.
You didn't see the thing about the pigs?
Maybe I glossed over that part.
Well, one of the irony of ironies is that because when you have more than 100 to 150,000 people in your care, you have different groups that actually, you have livestock and they raise pigs for slaughter, for bacon and for food and for pork. They spent almost $1 million, maybe $700,000 on misting systems to cool the temperatures for the pigs in their care. I'm not making this up. They had written policies that said when it got to a certain temperature, ironically 85 degrees, it was required that misters turn on to cool down the temperatures so that the pigs weren't endangered. Now, that is when I cleverly or kindly, however you want to put it, ask the administrators, what's more important, the safety of the humans under your care or your livestock? They all hated the question and answered honestly, of course. But the optics of that were devastating to the state. And not just on a pure optic level. Yes, right. It's bad that you're actually treating livestock better than the people in your care. It took a while for the state to realize that. Mike and I were in New Orleans at a Fifth Circuit argument on this issue in one of the wrongful death cases, and the judges said, "Do you know how that makes you look?" And the response was, "Yes." And the response from the Fifth Circuit, I think I'm quoting, was, You do?" And so that was the mindset.
You say you do, but you act like you don't.
Yeah. And in no uncertain terms, the orders that the Fifth Circuit issued to the department made it clear that they didn't think they understood and that they needed to change. Many times we would go to the Fifth Circuit and be told, and the question would be, what do we have to do or say to get this to change? There's a lot of deference on the Fifth Circuit to any administrator. Perhaps they're in a better place to judge how to run the prison than courts are. And I concede that as an initial matter that is true until you give up the right to run that when you purposefully, knowingly, over the course of 10 years, choose not to solve a problem. And, we were unapologetic when that question came up. What do you have to do? In no uncertain terms, you have to tell them that they're wrong. And to the Fifth Circuit's credit, they did exactly that. Not once, not twice, but 3 times. And they did it in such a way that there is now it is not up for debate. There is a clearly established right to be protected from these temperatures, and the failure to remedy them puts the administrators, puts the state at risk. And so, again, I think that the system as a whole, from the courts at the district level to the courts at the Fifth Circuit level, did exactly what is intended. They evaluated, they did call balls and strikes here. They saw we provided them with a constitutional framework in which something egregious was going on, and they called it. And it wasn't strike one, strike two, it was strike three. And again, while it took too long, too many man hours, too much in terms of resources, the state spent more money litigating the case than it will cost to air condition not one but two prisons. Eventually, they came around. I liken it to chiseling granite, and that's exactly what it was. But at the end of the day, we have at least a solid base sculpture to protect these inmates, and they're pretty proud of what they've accomplished. And it is kind of cool that we live in a place where, what Mike said, the lowest among us, the meekest among us, can really challenge that type of authority. And when you get to go tell people who showed some real courage in terms of being the face of this litigation, Mike and I might have spent a lot of time and we may have spent a lot of money litigating this case, but there were 5 or 6 inmates who had to bear the potential brunt of potential retaliation and just being the face of this, and they did so with grace and humility, and really deserve a tremendous amount of credit. Now, they were in prison because they did something wrong, and they'll be the first ones to tell you that. But they stood up, and they took on, one of the biggest bureaucracies with $3 billion budget that ignored them for years and said, I'm suffering, and it's not just me, it's other people who are suffering. And we litigate some really serious cases, and some are interesting and some are devastating where families are lost. It's always in the cases where there are real serious issues that you get people who really are doing it for something more than themselves. And these inmates deserve a tremendous amount of credit and a thank you. And
did the inmates who did step up and took the risk of being retaliated against? I don't know a ton about prisons, but I know that that's always something that an inmate has to be afraid of. You just kind of keep your head down and hope that it doesn't get lopped off by somebody who's suddenly got their attention on you. Did they get anything out of this other than some air conditioning?
No money at all. No money at all. What they got out of it is a safe prison, which was the whole point here.
Yeah. And they're pretty proud of that. And I think at the end of the day, they're happier than if they had gotten some modest payment. They own this in the purest sense of the word. They did it for the right reasons, and it's pure altruism on their part. Now, they get something tangible that you really can't put a price on, which is the fact that you don't have to walk down the hall to chow and think you might die of a heat stroke.
Right.
But it's not just air conditioning. It's the manner in which the state tried to put Band-Aids on this bullet wound. When the state realized that they did need to provide air conditioning, they tried to come up with this ad hoc way of doing it. And so they would have rooms at the prison that had air conditioning. Now you might ask yourself, why, if you're going to air condition some of the prison, do you not air condition all of the prison? A darn good question, and the only answer is a rotten one in terms of our own humanity. It's because we didn't care, and we chose not to. But needless to say, the fact that the prison system tried to put this Band-Aid on ultimately helped us prove our case, because it was very important for us to show that air conditioning was necessary and that it was the only thing that really would work. If you had to air condition the entire facility to protect people. What they were doing was they had a barbershop room, and they would let people access it for minutes at a time, and they'd have people standing out in the hallways. And again, I'm a lawyer, and so we can be accused of perhaps being fat and happy and not the strongest of sorts. But they forgot to have chairs for people to sit, and so you had people in walkers and people with disabilities having to stand in hallways. And with a straight face and open court, the state's lawyers were saying, well, that's satisfactory. And so the absurdity of it, of it was exemplified by this. I forget if it was day 2 or 3 of the last trial that we had, when we pointed out that a chair might be something helpful. Guess what happened? Everybody had chairs the next day. This happened time and time again. Water. Water was one of these solutions, but they forgot to give people cups. They didn't issue cups, and so they were telling people to drink water, but they didn't have a cup to drink out of. And when we pointed out, what is wrong with you? Why are you not giving them cups? How dare you tell us how to manage a prison system? But, it's just a matter of, look, we had to come up with lots of common sense solutions. And while initially there was such attention in terms of ever taking any of our suggestions, at the end of the day, these common sense solutions all got adopted. And now in prisons where you come into them from these air-conditioned county jails and come into these hot houses, which is its in and of itself a separate danger, now they're issued cups. Now they're encouraged to drink water. Much the way you might see it if you stop at a store in Texas. You'll see a chart of be careful if you're dehydrated. Mm-hmm. They're doing a lot more of these common sense things. Their training actually acknowledges the fact that you can die and be harmed. There's much less of a cover our behind into a let's proactively solve the problem. I hope that the legislature comes through for not just the PAC unit, but for all the prisons, and that we eliminate this problem once and for all. Because, I grew up on the East Coast, but I'm a Texan, and the nice thing that I found about Texas is that when I talk about this case to far right, left, most people are very surprised that the prisons aren't air conditioned, and very receptive to the fact that we need to air condition the facilities, not just for health reasons, but for this basic reason that once you take somebody's liberty away, you've got to protect them, and to subject people to an additional danger when it's your job to protect them. I mean, Mike may say it's about the Constitution, but there's an old philosophy at this law firm, and it is simply this: if you can say the words "that ain't right," it's because that ain't right, and it matters. There's a great line from Miller's Crossing. You don't need to be right to win the war, but it sure helps. And that was kind of the theme. And again, every now and again, you have an opportunity to really fight for something you believe passionately and that you're right about. And this was one of those cases. And we've represented some families who were devastated by losses, but I doubt we'll ever have this kind of impact. And so as lawyers, we take tremendous pride in that. And, the irony of ironies is we didn't do this case for this reason initially. But once we came to learn about the danger and the sheer stupidity of not fixing it, and saw the effect on the inmates, who are just people who made mistakes and who are trying to live their lives, it was just a tremendously powerful experience, and to have it resolved this way, I'm just so proud of the work we did. But I'm equally proud of kind of the lawyers on the other side who kind of came to terms with helping the men and women. And there was one lawyer in particular on the other side who said to me, Jeff, I don't want anything to happen to these men either. And once we heard that and we saw that we were working towards a solution, that's the best part of being a lawyer, is when you can kind of craft something and you stop being at loggerheads. Though the fighting can be fun sometimes, when you're talking about public policy, and that's what this was at the end of the day, you need both sides to really make that happen. And it did. And it was a neat to be part of that experience.
You guys took on tremendous risk in terms of, the order talks about how many hours. And I know there are a lot of lawyers that were involved in this, but there were close to 10,000 hours that were submitted, and a lot of the hours were taken out of your submission. and hundreds of thousands of dollars that you guys spent with no guarantee you were ever going to get that back. I love the angle of it. It's not an angle. That sounds like it's some sort of a spin room. But you've got these guys who they did something wrong, and that's why they're in prison. But that didn't mean they couldn't then do the right thing and stand up at risk to themselves. You don't think of great stories coming out of prison houses, but this is one of them. So thank you to you guys for all that you put into this, for putting your blood, sweat, toil, and tears and talents into it. For folks who are listening, and I know you guys do more than representing prisoners and families of prisoners, but if they have need to get, God forbid, nobody wants to need your services, but if they do, how can they find you?
You can go onto the internet, and it's the Edwards Law Group. It's Mike Singley, Jeff Edwards, and Scott Medlock, and David James, and Wallace Nader. We're blood and guts personal injury lawyers who represent a lot of victims and have been very, very fortunate enough to have some success on a number of cases in the civil rights arena and the products liability arena. And if we weren't fortunate enough to have been successful in other cases, maybe we couldn't have afforded to do this case. I'm glad that we were. And while we did spend a tremendous amount of time on it, it became kind of a passion. And
it's more than just a case.
Sure.
Yeah. And but yeah, if again, we represent people who are badly hurt, and so it's Edwards Law or the Edwards Law Group in Austin. Jeff Edwards, Mike Singley. If anybody wants to contact us, I appreciate that. But this one's pretty pure, and I really, really hope that it is the start of better things to come for the prison system, and that I really do hope that the comments that the administrators are making and that the legislators are making about there being a sea change at the agency stay the course, because all of the people that are working there at TDCJ and the University of Texas Medical Branch really have a unique opportunity to help people and protect people. And by and large, that's why they're there. And so I really hope that sea change stays true. Anyway, thank you for your time as well.
Thank you guys very much.
Michael, thanks for giving us the opportunity.
My pleasure. This episode of the Personal Responsibility Lawyer Podcast is brought to you by my law firm, Lovins Trosclair, where we use the civil justice system to hold people responsible for irresponsible choices when those irresponsible choices cause serious injuries and death. Yes, we are personal injury trial lawyers, but we're a bit of a different breed because we approach our cases differently. I hope you don't need us, but if you need us, please call us. Call 512-535-1649 and tell us you heard about us on the Personal Responsibility Lawyer Podcast. Or you can also go to our website at LT Legal Team, that's L as in Lovins, T as in Trosclair, legalteam.com. We're here to help. Thank you for listening to the Personal Responsibility Lawyer Podcast. If you like what you've heard or if you've learned something interesting, please do me a favor and rate the show on iTunes. It really does help. You can get more information about this show, including the show notes, at my personal website, michaellovins.com. Okay, it's silly disclaimer time where I say stuff you already knew, but I gotta say it anyway so I keep the State Bar happy. This podcast is not legal advice. You listening to this podcast does not make me your lawyer or you my client. Neither does it make any of my guests your lawyer. If you want me to be your lawyer, contact my office. If I can represent you, we will execute a written contract stating the specific terms under which I agree to represent you. Did you really need me to tell you that? Man, I hope not. Also, I am not certified by the Texas Board of Legal Specialization as a personal responsibility lawyer because they don't even know what that is. Neither am I certified in any of the areas of specialty that they actually do recognize. And until next time, I'm Michael Lovins for the Personal Responsibility Lawyer Podcast and Lovins Trosclair. See you next time.